For foreign investors in Vietnam, business succession planning is often treated as a future concern. In reality, it is a present structural issue. If succession is not designed deliberately, it will be determined by default legal rules. Vietnamese law treats inheritance, corporate ownership, and land use rights as interconnected but distinct legal domains. When a foreign shareholder dies, these systems intersect. Without coordination, conflict is almost inevitable. Succession planning is not only about who receives economic value. It is about who controls voting rights, management authority, and strategic direction. For operating businesses, control is decisive. If a foreign investor dies, without a coordinated will and corporate structure, their shares or capital contribution form part of the estate. Heirs may become the legal successors to those interests in accordance with inheritance law and corporate regulations. However, admission as a member or shareholder may still be subject to company charter provisions and sector-specific conditions. This outcome may not align with business continuity objectives. Vietnamese inheritance law may divide shares among multiple heirs. Fragmented ownership complicates decision-making. It can paralyze governance in closely held companies. Under Vietnamese Civil Code, certain compulsory heirs are entitled to a statutory minimum share of the estate, calculated as a portion of what they would receive under statutory inheritance. This entitlement applies to the deceased's ownership interest, including business shares. Strategic allocation in a will must therefore account for mandatory heirship exposure. Shareholder agreements are critical governance tools, but they do not displace inheritance law. Upon death, ownership interests pass under succession rules before contractual mechanisms take effect. Corporate documents must therefore be structured to operate coherently once inheritance rights arise. A properly structured succession plan aligns the will with the company charter and shareholder agreements. Transfer restrictions, buy-sell mechanisms, and voting arrangements must be coordinated. Inconsistency creates litigation risk. Buy-sell provisions can allow surviving shareholders to acquire shares from heirs. This protects operational stability. However, funding mechanisms must be realistic and enforceable. If the business holds land use rights in Vietnam, inheritance affects asset control. Property registration and corporate ownership interact. Failure to plan may freeze strategic assets. In regulated sectors, foreign ownership may be subject to statutory cap or licensing conditions. A transfer of shares through inheritance may trigger investment registration adjustments or require regulatory approval. Succession planning must evaluate sector-specific compliance before control assumptions are made. Offshore holding structures may centralize ownership at a foreign corporate level. In such cases, inheritance may occur at the holding company layer rather than directly over Vietnamese shares. However, the underlying Vietnamese company and its assets remain subject to domestic corporate, investment, and land regulations. Conflict of law analysis remains necessary. For long-term investors in Vietnam, succession planning should extend beyond immediate inheritance. Governance frameworks for the next generation reduce internal disputes. Family alignment supports business continuity. Cross-border succession may trigger reporting obligations in multiple jurisdictions. Coordinated planning reduces tax inefficiencies and compliance risk. Fragmented planning increases exposure. Business succession planning should address two scenarios: unexpected death and planned generational transition. Both require structural clarity. Temporary authorization does not replace ownership transfer planning. Upon death, powers of attorney cease. Only legally structured succession governs control. Many business disputes in Vietnam originate from unclear succession planning. Operational paralysis, shareholder litigation, and asset freeze are common outcomes. The financial cost often exceeds the cost of preventive structuring. First, review shareholding structure under Vietnamese corporate law. Second, align estate planning with forced heirship and inheritance principles. Third, coordinate shareholder agreements with succession intent. foreign investors often focus on regulatory compliance and tax optimization. Succession planning should be viewed with equal seriousness. It is a core governance issue. In Vietnam, business succession planning is not automatic. Inheritance law will apply unless replaced by deliberate structure. For foreign investors, continuity of control requires proactive legal alignment. Without it, succession becomes reactive rather than strategic. If you are a foreign investor in Vietnam, business succession planning is not merely an inheritance exercise, it is a governance and control decision. Shareholding structure, compulsory heirship exposure, regulatory approvals, and corporate documentation must operate as a coordinated system. To design a succession framework that protects both ownership and operational continuity, contact LTS Law at lts.com.vn for structured advisory support. In business, control should never pass by default. It should pass by design.